Hello everyone, I'm Vincent White. I'm an employment attorney and I'm dressed in black today because we need to put ourselves in the mindset of the villain. I'm only kidding, but today we're putting ourselves in the minds of defense counsel, right? It's a tough job. They have to defend the people that we're accusing of, office sexual harassment, office discrimination. I can't imagine any of them want to do that. Right? And they're not always wrong. I mean, listen, sometimes people bring cases that are not that realistic, that maybe the events didn't entirely happen the way they said. So, not every case that a defense attorney takes is something they need to feel bad about. So they're not bad. They're not bad people, but they are between us and your money, right? They're the ones defending the people we're going after. And often clients will say to me, I thought I had a good case. Why are they not caving to our demands? We're asking for $100,000 and they'll only offer us, who knows, $60,000, right? And there's a bunch of reasons why they might be doing that. We're going to go through some of the possibilities. We'll never know in a given case what it is necessarily, but I think it's important for you to think about and to know some of the things that could be happening in an employment defense counsel's mind that leads to the decision to not settle, to not give you exactly what you're asking for, right? The first reason they might not be doing that, right, they might not be giving you as much as you want, is this. So you sit down with your attorneys, you do a damages calculation, you arrive at a dollar figure, and you say, okay, this is the amount that I could hope to win at trial, potentially. You can never know, right? You're ballparking, it's an estimate. But it's based on some pretty good data and a lot of formulas and a lot of thought and time going into these calculations, right? And defense counsel might hear your number, right? Maybe you're asking for, I don't know, $300,000, just as a hypothetical. And defense counsel might hear that number and might say to her or his self, boy, I do think we have some exposure on this case. I think we could definitely lose a trial. We could lose big. And I don't even necessarily disagree that we could lose $300,000. But I think maybe this plaintiff only wins 60% of the time. So maybe they go to their client and they say, hey, you do have some exposure here. This is a problem for you. You should probably pay this person. But why don't you try paying them, 60% what they're asking for? Because honestly, we think they're only going to win about 60% of the time. That is a legitimate thing that defense counsel engage in. I know they think that way sometimes. They tell me they do, right? I know many defense counsel, and they're not villains. As much as I joke about them being villains and wear my black shirt to make them feel bad, they're looking at cases and saying, oh boy, this person's got to get paid. This can't go to trial. The client messed up, but I don't think we should pay what they're asking for. So that's the first reason why maybe you're not getting what you asked for. The second reason is there's often something you don't know, right? I'll use an example that has all the identifying information scrubbed from it in the entirety of the case. Had a client, we were very sure it was discrimination in the workplace, but it turns out that there was a bunch of emails from the manager saying, hey, I thought this person was my friend, but she came to me one day and said these horrible things to me. And it really hurt my feelings, and I don't like her now. It wasn't discrimination. It was because of what that person said, right? And that's something you may not know about. You may not know the manager feels that way, but it might be a really good defense against a discrimination claim, and it might make defense counsel say, I'm not going to pay this person. I've got really good evidence, and I haven't had to turn it over yet. So the plaintiff's counsel doesn't even know about it yet, and I'm laying a trap for them. I think I'm going to get them, right? Okay, that's a legitimate reason why they wouldn't pay you, right? Not a great one. I hope that's not true in any of the cases that you're dealing with, but it's a possibility. It's something you have to plan for and deal with. The third possibility is you don't know what their witnesses are telling them. Right? You were there. You're the plaintiff. You're the victim. You know what you experienced. But the defense lawyer doesn't. Defense lawyer, she or he wasn't there, right? So who knows what the other people who were there told this attorney. They might listen, so the plaintiff came in and pushed me around and beat me up and treated me like garbage, and it was never discrimination. Well, that attorney is going to believe her or his witness because that's their job, right? So that you don't know what they're being told. They might think they're sitting on a great defense because witnesses are telling them things and they're believing it. That's the third reason. The fourth reason is a bit cynical, but there's going to be some rare defense attorneys who don't want to settle a case because they're billing by the hour, and if they settle the case, they're not going to be able to bill as much. So sometimes, some very bad defense attorneys tell their clients, oh yeah, we're totally going to win this at trial. We're going to get you fees. It's going to be amazing. It's going to be so great for you. You're going to feel so vindicated, and nobody's going to bring cases against you in the future because you paid us so much and we fought them off and made them look silly. It's probably not true, right? I mean, there's definitely cases that, defense attorneys pick to fight because they think they can win them. But in this situation, that's probably not true, because really what that defense attorney, with this rare, evil defense attorney, is thinking is, I just want to bill more. I need to bill this employer lots of money, and I don't care what happens to the plaintiff, and I don't care what happens to the employer. I just want to bill more. And at the end, we'll probably settle anyways. It happens. It's not good that it happens, and most attorneys don't, hopefully, in our field, act that way. And I'm certainly not accusing many or all or even most, of employment defense attorneys of thinking that way. But I've run into a few who I think pretty confidently I can say that is their MO. Next is sometimes they just don't pay because the company can't afford a big settlement right now, right? The defense attorney might go to their client and say, hey, you are going to potentially lose huge here. You really messed up. You need to pay this person. And the employer might respond, yeah, we know. Yeah, we messed up big time. We did some pretty hateful things there. And we really want to make it right. But we just don't have any money right now. We can't pay the $500,000 they're asking for. We just don't have it. We can't do it. And so they'll say, listen, just fight the case for now, and if we can come up with the money, we'll try to make a settlement offer later. That's a reality, right? I mean, if you're asking for big numbers, a lot of employers might not have it at that moment. So important to keep that in mind. And I apologize for my phone ringing. And the last reason, and this one has more to do with you than with the defense attorney or even the employer. The last reason they might not be paying you what you're asking for is that a lot of clients don't really want to listen to their attorneys, right? If your attorneys say, hey, we think you should make a demand of, $100,000. We did your economic damages and your emotional damages, and we looked at the punitives in play here, and we really think we should put a demand of $100,000. And you say, no dice, I want $1 million. Well, the defense attorney knows you probably, in this scenario, can't win $1 million. Right? It's probably very unlikely you're going to win $1 million if your attorney's recommending you make a demand for only $100,000. But you might not care, right? Some plaintiffs don't care. They say, no, I'm positive if a jury hears my case, they'll give me $1 million, or $10 million, or $100 million, right? I've heard it all. So if you're ignoring what your attorneys are asking for, or recommending you ask for, there's a really good chance defense counsel might not even bother responding, right? They're just going to say to themselves, this client's not listening to their attorney, so one, I can't have a real settlement negotiation because they're not talking about numbers that are realistic in the real world, and two, it's a really good sign for defense counsel when plaintiffs don't listen to their attorneys. It makes them feel confident, like, when depositions come up, they're not going to listen to their attorney again, and they're going to say silly things their attorney coached them not to say because they're not listening to their attorney. And that's going to help the defense attorney make the witness look like a fool in deposition and potentially win the case, and that's not good. But they get a big boost of confidence when they know the plaintiffs are not listening to their counsel, right? If you're the plaintiff's counsel and you do this every single day, this is all you do, this is how you make your living, you help people in this scenario, and you know the ins and outs of it, your advice is probably valuable. And if your client's ignoring it, that's going to be problematic. That's going to cause a lot of risk down the line, and it's often going to make defense attorneys say, oh yeah, I don't have to talk settlement. I don't have to take this seriously. I'm not going to respond to $1 million when I think the case is worth $100,000. And that happens. So this is not an exhaustive list. There's a lot of other reasons why you might not be getting exactly what you want in terms of response to your settlement demand. But it's something to get you to start thinking of what might be going on and all the factors in play. It's a very complex negotiation. There's a lot going on. And I thought it might be valuable for some plaintiffs to hear a couple of the things that could be going on. So I wish you luck. I hope you get exactly the settlement amount you want. And I hope you listen to your attorneys. Take care, everybody.